So basically what happened was we pulled a time before and then we teach them. So what did they do?
That's what I'm saying.
What does that mean?
Can you click on those specific? Click on those
Are y'all ready, Justice? Are you ready?
Yes, ma'am. There's one thing I want to get over. Well, actually, I think I'm trying to sort one thing out with Mr. Slovenski.
Are y'all ready? What were you?
I am, y'all waiting to make sure that everyone's on the same page.
Opinion was wrong, and after we've clarified that outside the presence of the jury, I discussed this with Mr. Slovenski, and he is taking back that statement that DPD's work based on that was sloppy.
All right, I don't believe you said that in front of the jury, though, did you?
No, he did not. That's why I'm doing this outside the presence.
Okay.
If I may, he said that in response to a question asked by Mr. Lord. I do not intend to offer a quality control evaluation opinion of the Dallas Police Department's work or anything specific to an evaluation of Mr. Freeman's or Officer Freeman's work. So I'm going to ask him what they asked him that. So I don't intend to get that. It's not in front of the jury. I would like to state, though, Defendant's Exhibit number 5, which was admitted into evidence after the second 705 hearing. Counsel for both parties and with the approval of the court agreed that 2 pages or slides from that PowerPoint slide and from the physical exhibit that is in evidence would be removed from the slide. I have done that with the court reporter. Those 2 pages have been removed. It's been restapled. The PowerPoint, the electronic one, has been modified to remove those 2. So I've changed an exhibit. I just want to make the record that I've done that with the consent of the court of the state. The second thing is, in the second 705 hearing, it was brought up that one of his opinions, and this relates to the same 2 pages, was based on a PowerPoint provided to him by me in discovery. It's the last one I received from the state. That is not the final one, which is the whole reason for the controversy over this. In light of the fact that I gave him the last one received by the state and I have agreed that the state will not cross-examine him on that, since I am not going to offer it in direct testimony from the jury.
I have no issue with that. As long as he's not expressing that opinion, I'm good.
All right, thank you.
Ready to do?
Yes, sir. Mr. Slovenski, you can get back on the stand if you wouldn't mind, sir. read back to you where we concluded?
Next. Oh, no, right there, go back.
And we've been at the point where he's talking about,
I don't want to repeat anything that we've already said in front of the jury, if we can avoid it.
he was starting to talk about the how the tower signals work and what sectors and so forth, and then we clarified that in the second set of 5 years.
Okay, Mr. Slovenski and Mr. Milner, do you all know where you're starting at?
Exactly, Your Honor.
Okay. Do you need Mr. Slovenski?
That's not mine.
All rise.
Be seated. Mr. Milner, please proceed.
Mr. Slovenski, did you, at my request, look through the actual cell phone dump? The actual cell phone dump from Kristopher Love's telephone?
Yes.
In there, did you find the cell number associated with the device belonging to Crystal Cortes?
Yes.
Was that cell phone number identified in the contacts of Mr. Love?
Yes.
How did Mr. Love identify Crystal Cortes in his cell phone?
As Crystal.
And for the record, Crystal?
That is correct, sir.
Is that what this slide is showing us?
That is correct.
The next slide, is that a blow up highlighting it?
Correct.
Did you find the phone number through all of this, any communication between the devices of Brenda Delgado and Kristopher Love?
None.
Were there communications, both voice and text, between Brenda Delgado and Crystal Cortes?
Yes.
All right, there are references in some of the slides that you've created where the name for Crystal Cortes is spelled Cortez.
Correct.
Is that the way you received these records?
Correct.
The way you received them in terms of discovered production?
Correct.
Or did you just replicate the name exactly as it was provided to you?
Correct.
All right. Bottom line, if it's spelled Cortes, if that's how it's really spelled, then that's an error on the records you were provided, not on something you did.
Correct.
All right. Did you examine the cell phone company records for the phone associated with Crystal Cortes?
Yes.
What else did you examine as it relates to the device, telephone, associated with Crystal Cortes?
I examined the international mobile subscriber identity number, which is for the SIM card, and the international mobile equipment identity number, which is associated with the cell phone.
All right. In layman's language, what are these numbers?
These are unique identification numbers assigned to the device and assigned to the SIM card.
Would it be comparable if we say the physical, and I'm holding up a cell phone in my hand. Is there a number, a unique number assigned to this cell phone?
Correct. It's called the IMSI.
What does that stand for?
International Mobile Equipment Identification.
All right. Is that like a VIN number in a car?
Correct.
Would every single cell phone ever, wherever, have its own number?
Yes.
Did you say IMEI or IMSI?
IMEI for the phone.
Okay. All right. In the phone, is there something called a SIM card?
Correct.
Is there also a unique identifier for that SIM card?
Yes.
Can you, if I were to start talking with this telephone last Monday, and then today, Thursday, I changed the SIM card, and then you looked at these cell phone provider records, could you tell whether I'm on the same phone with a different SIM card, or how would you know that, or could you know that?
I would know that you were using a different phone with the same SIM card if you just switch the SIM card from one phone to another.
All right. So the records, when you look at these cell service provider records, do they give you the, and I'll call it a VIN number just to make it as simple, do they give you the VIN number for the physical phone itself?
Yes.
Do they give you the VIN number for the physical SIM card itself?
Yes.
What does the SIM card do? What is that?
It's basically, I call it the sergeant at arms. It guards the door of the phone. You cannot access a tower in a phone without a SIM card present. It is the door that opens the communication between the tower and the phone.
If we go back to the records provided in connection with the phone for Crystal Cortes, do you have the cell service provider records?
Yes.
What are the dates again that you have for that?
For Crystal Cortes, they began on August 23rd, 2015 at 9:37 a.m.
All right. And those are the cell service records?
Correct.
When do those end?
September 4th, 2015 at 12:57 a.m.
And so when you're getting that specific 12:57 a.m. on September 4th, 2015, is that just based on the last recorded transaction data shown in the records?
Yes.
Is that how you come up with a very specific time, 3 minutes to 1 a.m. on September 4, 2015? Is that the last transaction on those cell phone provider records?
Correct.
Now, if you want to get those records, do you get that information from this physical phone?
No.
How do you get it? How would the police get it?
They would serve a warrant on the cell service provider.
So that is totally independent of the actual physical phone.
That is correct.
Did you also examine records that the police obtained from the physical phone itself?
Yes.
And by physical phone, I mean the one associated with Crystal Cortes.
Correct.
What did you look at?
I looked at the Celebrite report, which was an examination conducted by the Dallas Police Department.
Is Celebrite the recognized way to do this?
Celebrite is one of the mobile phone data recovery softwares out there that's used many times by police departments.
All right. If I was going to do this, we had my phone here, what would we basically have to do this?
To do
Just
an examination.
Just to generally describe for the jury, what would you do? I give you my phone, you want to get a Celebrite report, how's it done?
Okay. Basically, you would have to protect the phone, which means you would put it in airplane mode, and you would double check the record or your device to make sure that all communications with the tower, Wi-Fi, Bluetooth are turned off. then the device is then hooked up to a Celebrite machine, physical machine, or a computer with the Celebrite software on it. The Celebrite software will then recognize, you will then be given a screen where you can then fill in information. Who is the extracting detective? Who is it for? Any other type of information that you wish to have included in the report.
Is that routinely done by law enforcement?
It should be.
Was that done here?
It appears to be.
All right, now looking at that Celebrite report related to Crystal Cortes, from that Celebrite report, can you see the data that is physically on the phone?
You could see the data that they recovered.
Can you see by looking at the Celebrite report, can you get the VIN number for the SIM card?
Yes.
From looking at that Celebrite report, can you get the physical phone VIN number?
Yes.
So these two unique identifying numbers can be obtained from both the records that you got from the phone company and from the Celebrite extraction.
Correct.
Here, are you able to determine whether Crystal Cortes gave them the physical phone that she was using on the day of this murder?
It was a different phone.
So if we construct our timeline, first, what are the dates of the records? When you go back to August
23rd.
So we're more than a month, 10 days-ish before. May I stand up front just for demo purpose?
You what?
Can I just stand for demo timeline deal?
Yeah.
Okay. So that this is clear, August 23, you start looking at records from the cell phone company, correct?
Correct.
Is the number, the VIN number for the phone, is that a long number?
Yes.
All right. Could you give us the last 4 digits of that number just for record identification purposes? This is by the phone company records. What physical phone was Crystal Cortes using?
It ended, the IMEI number ended in 8590.
During this time, 8590, the physical phone, if we go day by day by day until we get to September 4 at 3 minutes to 1 a.m. on September 4, 2015, is it the same physical phone that is used based on the cell phone company records?
Yes.
Now, go back in time to August 23, 2015. What SIM card is being used?
The SIM card ends in 5278.
And from August 23, is that same SIM card continuing to be used until September 4, 2015 at 12:57 a.m.?
Yes.
Are there, by the records that have been obtained by the police, is there any more action on that cell phone and that SIM card after 12:57 a.m. on September 4, 2015?
Not on the Metro PCS records.
Now, that time frame, that 10 days-ish, same cell phone number, not the number, same physical phone, same SIM card until 12:57 a.m. on September 4, 2015, correct?
Correct.
Now, are you able to determine, looking at the extraction report, whether the physical phone that Crystal Cortes handed to the police had the same SIM card in it that had been used throughout that 10-day period?
The same SIM card, yes.
Was it the same?
SIM card, yes.
Are you able to, looking at the Celebrite report when the police downloaded the phone, are you able to determine whether that physical phone was different than the one she had been using up until 1 a.m. that same morning?
Yes.
Was it the same?
No.
Pass the witness.
Mr. Slovenski, I want to ask you to pull up one of your slides on there. It's the one talking about the Brenda Delgado device on September 1st, 2015. 9:36 a.m. Yes, sir, that one.
Okay.
Okay, so just so we're clear on this, what you're telling the jury is that at 9:36 a.m., Brenda Delgado's phone is hitting a tower at that location. Just to be specific, would you tell the jury where that is?
Again, I can give you the general area of what it says because I don't know Dallas.
That's fine.
Okay. It's near the intersection of where North Houston, Harry Hines comes in on highway, and I'm not sure what that is, 77, or it's covered up by the.
The reason I ask is because today's the first time I've ever seen this, so you got to work with me on this. So I want to go back to 7:41 a.m.
Yes.
At 7:41 a.m., Brenda Delgado's phone is hitting down off of 67 in the Redbird area, correct?
Correct.
Okay. Then at 9:36, it's hitting at the location you've got depicted on Defense Exhibit 5, correct?
Correct.
Now at 11:16 a.m., Brenda Delgado's phone is again hitting off of a tower down off 67, South Dallas there by Redbird. Is that true?
That's correct.
So it's down south off 67 Redbird, then back up north, and then back down south. Is that fair to say?
Yes.
Now, I want to refer to State's Exhibit 392, and that number may not mean anything to you, but it is the PowerPoint with the slides that have the tower locations. There's how many slides? 26 of them.
Okay.
392. The State's Exhibit 392 that's got the slides with the tower locations and the times of the calls with Crystal Cortes, Brenda Delgado, and Kristopher Love's phones. Does that ring a bell, or do I need to show you a hard copy of it?
Because this seems to be different that we discussed earlier.
This is exactly what we discussed. You can
Okay.
approach. I think this will be easy.
Okay, cool.
Approach the witness show.
You may.
I'm just going to show you a hard copy of State's Exhibit 392. Is this just to make sure this is something that you have seen and reviewed before?
Yes, sir.
Okay. I want you to flip to. Let's go to slide. Let's start with slide 20 first of all. Now on slide 20, and I think we're going to bring it up on the screen here. And we're going to show it up on the screen, so unless you need to refer to this, I'm happy to do that if you want to.
We're fine.
Okay. On slide 20, what that indicates is that Brenda Delgado's cell phone was hitting off of a tower basically at Royal and I-35, right by where there's a jack-in-the-box. Is that fair to say?
Correct.
Let me go back to slide number 19, and let me, just to be clear, I don't know if the jury can see that, that's September 2nd of 2015 at 10:30 a.m. and 26 seconds, correct?
Correct.
Okay, let's go to slide 19. And on slide 19, she's basically hitting off a tower that is in the same area, right there next to the jack-in-the-box, on September 2nd, 2015, and that's at 10:22 a.m., just a few minutes before. Is that fair to say?
Yes, sir.
Okay. Now, going back to your testimony regarding the SIM card and the telephone and all that, I want to make this clear that when we're talking about call data records, when we're talking about tower records, switching the phone, switching the SIM card doesn't matter as long as it's the same account or phone number. Is that fair to say? And I may be oversimplifying it, but
If you change the SIM card, you could change the telephone number, possibly.
Assuming it was the same telephone number, would it
Okay.
still be the same records?
Yes, sir, I believe so.
Okay, so it doesn't affect, you know, if today I've got my phone and I'm calling it and it's pinging off towers, it's going to log those calls if it's Sprint that I have, for example, right?
Okay. Mhm.
Okay, and if I go change my phone but I keep my number, tomorrow I come back, I ping off towers. If I pull those records, it would be on the same record, same documents. Would you
Same
agree with
Sprint
me?
record.
Okay. So let me ask you this. If Crystal Cortes told this jury that after the murder happened, that she switched phones, based on your examination of the documentation, the dumps, the cell phone dumps, would that corroborate her saying that?
Objection assumes facts not in evidence. She said it was a week before.
Could you repeat the question?
If Crystal Cortes said she switched phones, would she be telling the truth?
Same objection.
One more time.
If Crystal Cortes says she switched phones, would she be telling the truth?
Correct.
Yes? She would be telling the truth.
If she's, well,
That's a yes or no.
I didn't hear her testimony, so if she said, I know this is not a trick question, but I just want to make sure that I'm stating correctly.
I think you already said correct here. I'm not trying to put words in your mouth, but
No, but I also want to rethink this. Say it again now.
Well,
Could she have switched?
Mr. Slovenski, let me back up a second. We had a hearing outside the presence of this jury, and I asked you this very question, and without hesitation, you said yes.
Ask me the question again.
The question is, if Crystal Cortes said she switched phones, would she be telling the truth?
Yes.
Thank you. Now, I want to refer to State's Exhibit 150, which is already in evidence, and we had a chance to talk about, these are the cell phone extraction from Brenda Delgado, and just, again, so we're on the same page. You know what I'm talking about.
Yeah, I do now.
We talked about that earlier. Okay, so I want to show you an excerpt from State's Exhibit 150. And I've kind of made it easy to read here. So this is an excerpt from State's Exhibit 150. And so a call log, there's a call log, and right above where the yellow sticky is, does this indicate a deleted call?
It appears to be so.
Now, I'll do the math for you, because you kind of taught me how this UTC stuff works. If it says September 3rd, 2015 at 1:31 and 49 seconds a.m. UTC, that's actually 8:31 p.m. on the 2nd of September here in Dallas, isn't it?
Yes.
So, if the murder were at 7:44 p.m., that's about 45 minutes later. Would you agree with me?
Say that again.
If the murder happened on September 2nd at 7:44 p.m., this phone call that was deleted is about 45 minutes after that. Would you agree with me?
I agree.
And you'd agree with me that this phone call that was deleted from Brenda Delgado's phone was from Crystal Cortes.
Yes. Her device. I can't prove it was her in her physical possession.
It was deleted from Brenda Delgado's phone.
Right, but it came from a phone with Crystal Cortez's number.
Right. A phone call from Crystal Cortez's phone number came to Brenda Delgado, and Brenda Delgado's phone, it was deleted.
Appears to be so.
It is or it isn't? Yes or no?
Yes.
And we flip to another excerpt from State's Exhibit 150. Now, does this appear to be a text message on September 4th, and I'll convert it, at 10:38 a.m. and 29 seconds, that was on Brenda Delgado's phone, and what it says is, "We are all clear, call me FR." You see that?
Yeah.
Okay. Now, isn't it true that that message on Brenda Delgado's phone was deleted?
Correct.
Mr. Slovenski, that's all I have. Pass the witness.
The text message did not say who it was from, correct?
If you could put the record back up, I could look. Start the very beginning. Okay. Now keep going. Keep going. Keep going. Keep going. No, sir, it does not.
But you saw messages, text messages specifically, between Crystal Cortes and Brenda Delgado, correct?
Correct.
And those were identified as either coming from one to the other or vice versa, correct?
Correct.
Now, he asked you, based on the records, if Crystal said she changed her physical phone, would that be a truthful statement? Your answer was yes.
Yes.
If she said she did it about a week before the murder, would that be true or would that be an absolute lie?
It's false.
If she's told this jury repeatedly that you cannot change the SIM card on that kind of phone, would that be a truthful statement or would that be an outright lie?
It would be an outright lie.
Do the records prove without any conceivable doubt that Crystal Cortes switched her physical phone sometime on September 4, 2015 after 12:57 a.m.?
Yes.
Do the records that were obtained by the police absolutely prove that not only can the SIM card be switched in that phone, but that it was switched in that cell phone?
Yes.
Pass the witness.
I have no further questions.
Thank you, sir. You may stand down. You're free to leave the courthouse.
Thank you, Your Honor.
Mr. Langer's witness.
Yes, Your Honor. Your Honor, ladies and gentlemen of the jury, the defense rests.
All right. Let me see the orders. All right, members of the jury, we're going to be in recess for the day. We'll see you tomorrow morning at 8:45.
All rise.
Mr. Mildred, did you want to lie on the record or no?
I will. We are at the point in the trial where the defense is obviously resting its case. We do not intend to call Ms. Delgado as a witness, and I'm doing it. Ms. Delgado was present. She's making this assertion with her consent. Please state your name.
Excuse me, raise your right hand. You do solemnly swear or affirm that the testimony you shall give in this cause will be the truth.
Yes, Your Honor.
At the request of the court, I've made an assertion on the record that I made here in front of everybody. Did you hear everything I just said? The
You
jury.
have to answer out, man.
Yes.
Did you? And the jury is not in the courtroom right now, correct?
Correct.
Did I make that statement with your permission?
Yes.
Did I do it accurately?
Yes.
Nothing further.
Anything further from either side?
Nothing.
All right.
Closing one.
close the record. Do you have a charge?
I do, Your Honor. All right. I have 2 hard copies, but I can also run back and email to everyone if y'all prefer that.
I'd like a hard copy, but you can email it to me.
I'll give you one and we'll give one to the judge, and then you guys can make edits.
Are you going to hard email one to Ms.
Yes, Your
Shannon?
Honor.
Yes? All right, if we can make sure that everybody's okay with the charge before we conclude today.
You want to do that by email, Judge? You want to stay
No, I
here?
want to do it right now.
Okay.
Matt, do you have another one?
Yes.
Yes, sir.
Would y'all like to pull out what evidence you want to argue with in the morning, so I can have it on the top, or you just want to do that in the morning?
before a 4-week notice, so I went in. I just sent it to you from my email there, so see if it would go through.
Let me know when you're ready, George.
I sent it to everybody. Just my own personal.
I didn't want, and yet you don't have any evidence for what? I thought you had sent out my one. They went to the
Right, I put it in the full parties, I think, because there's no conspiracy, it's just.
Yeah, good.
I agree with that.
I get why that. This one.
I know, but that's
No, that's fine. No, that's fine. Is this verbatim and includes this first sentence? Verbatim. Show me what this first sentence. I don't object to the context of this first sentence. So that's tell me when you have all person artists and
that way that's not it. That's the part
And we're taking out the specific intent.
show me what you
Under the mental state definition, and also we wanted all these specific intent.
the one you're instructing on specific intent to kill. Oh, yeah.
15 seconds.
There's, I guess, there's a problem. The last in the mere presence alone. What it says The way you've got to make this, mere presence alone is not sufficient.
I know. What is it that you're?
Read the sentence. The sentence is not from the code.
Right. So what do you want it to say?
I would say like the code says.
There isn't an actual, that's not the case law. The mere presence is a case law.
Mere presence alone is not sufficient to convict the defendant. Notice that the exact language that is typically used. That's how we work.
What is it? What page 5 under the law parties?
Mere presence alone does not make one party to the case. It's the presence of the city. That's right.
Sorry about this morning. I think we just did. Yeah.
So your questions alone will not constitute one party to an offense, is that all right? Are you all objecting to that?
Mere presence alone does not make one party to the case.
So I took out that letter C here.
Because the way we print it.
Yeah, I'll print it, but I just put it out last night.
Mere presence alone does not make one party to the case.
We just, okay. All right, we took out conspiracy, we took out conspiracy, we took out that all you want to take.
Pardon me? Question for you.
Yes, ma'am.
When I'm in the report, which is where I live, I can get snippets of testimony to show them closing. Is that possible or no?
All right.
The specific, you can tell me the specific part, yeah.
Yes, delete that.
But I mean, it's pretty hard to get into that. I mean, it's really only like 2 or 3 sentences.
Okay, yeah, research part, tell me the specific was, so I can look for it. If you give it to me, that ASAP, that'd be great. Okay.
So it starts with.
Should begin with the person's criminal responsible as a party to the case. Go to page 6.
Taking out both conspiracy paragraphs.
Those conspiracy paragraphs are gone. On the original page 6, first whole paragraph, the last sentence should read, mere presence alone will not make one a party to the offense.
I have does, you told me to put does.
Or does not make one a party. That's it. Or does not make one a party to the offense. Got it? Page 7, there are no changes.
I guess something else.
Page 8, no changes. Page 9, no changes. Page 10. Me too. I think we were. The first full paragraph should be. Page 10, well, the original page 10.
Oh, yeah.
You are instructed that you may consider all relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between defendant and deceased defendant, that one?
Right. I'll take that paragraph out. No.
Why?
That's not.
Yeah, that's a
That's
statutory.
a self-defense situation.
No, it's not, it's for any murder case.
That's statute.
Okay, I mean, to make your objection.
All right. I'll make my objection, but it is pointing out and emphasizing certain evidence in this case, which is common on the evidence.
It's a statute.
I'm aware of that. I know where it comes from. That's the relationship between the accused or the state of mind when you kill somebody in self-defense. I know where it comes from. It's inapplicable.
It doesn't have anything to do with self-defense, it's for murder cases. When you have a dead body, you're allowed to take in the circumstances relevant to the killing.
Prosecution for murder, the state defense shall be permitted to offer testimony as to all relevant facts and circumstances surrounding the killing and the previous relationship existing between the
That's an admissibility issue. It's not the same as the court commenting on the weight of evidence or pointing out or emphasizing certain evidence, which cannot be done.
But what this says is that they are being instructed under this law that they can consider that evidence.
And they're being instructed in another law that you consider all the evidence before you. This is doing exactly what I'm complaining about, which is emphasizing certain evidence.
Well, then let's take out mere presence alone, because that's the judge commenting on the evidence there.
That is a statement of law.
So it is.
That's a statement of admissibility. That is not the same as saying the judge can emphasize or
So
point out.
404B, the charges go in.
I'm taking out 404B.
No.
I don't know, you're not doing that.
No.
That would be this case.
Or objections.
What's 404B? Where's 404B?
Extraneous.
Extraneous offenses.
Oh, yeah. Okay.
It is not going to get this case reversed, particularly.
So we're going to ask for 404B.
Yeah.
Protection.
There was no extraneous offense.
You didn't say that before, George. Does that come later?
Yeah, it's later.
Hiring
It's later.
someone to commit assaults, not an extraneous.
What's that?
Hiring someone to commit
Yeah.
assaults, not an extraneous.
That is part of the crime that is allegedly indicted.
The indictment is alleged the killing of Kendra Hatcher
Right.
by Kristopher Love.
Right.
That is
But
correct.
So
Milton-
asking Moses Martinez to commit a crime is an extraneous crime to the killing
And
of Kendra
Milton.
Hatcher
And Jennifer
and
Calhoun.
Jennifer Calhoun. Those are extraneous to Kristopher Love.
We will definitely be requesting that.
Definitely.
We're requesting.
Excuse me, Justin. Okay. All right, so page 10, you want to take that out, okay. We're not. 11,
11, no objections. 12, no objections.
And the stalking, the cyber stalking, the following, the stalking, which he admitted in opening argument.
Those are crimes.
Stalking is a crime.
She doesn't meet the statutory definition. I mean, that's the.
Okay, then it's a bad act.
Yeah, but you got up and said she did.
all right, are we
stalk him.
ready to get on the record?
Yes, Your Honor.
All right,
Well,
we're
I need to see what the copy that we got
Print them
now.
off for both of us. All right.
Robbie, I'm gonna send you a new
Email.
version.
Still just going to print a couple.
I did lose weight. Now I'm on the other side. I'm heading back.
You're on the other side.
I was down,
Let's
now
see that.
I'm working my way back up. But I'll, after this, I'll come back.
Lose off, lose.
For real. Oh, yeah.
Oh.
And who was the goatee or whatever?
No, that's the ATM.
Oh, no, that was the ATM guy. What,
Yeah, no, we like the other one.
Throw me under the rug, et cetera. To what? To rob. Really? Oh, yeah, I vaguely remember that.
These two, I don't have.
He's a lawyer too?
Yeah, sure. Jason.
Oh, there was a lot of testimony, but that's because she was saying she thought it was the best vehicle.
I was telling him, I was like, if you saw him walking down the street, you would also have no idea that the
Yeah.
Oh, I mean,
You have some,
No, that's fine, that's fine. I know generally what you're talking about.
yeah, but then, but he's squared away.
Okay. Yeah, I'll start looking for a town.
That.
You don't have to make it up. Have to make- Yes, if I provide something to you, I have to provide it to them, and vice versa. If they came and asked me for part of testimony, I'd have to give it to you.
I feel like that's like one of his tools, is that he looks.
Well, not for her, but yeah, no, that's the court report.
40-year-old.
I can't make something for you.
Oh, and he's got like a mobile
You look at it and make sure.
and he's like,
I mean, most of them, okay, what are their accounts? They're not formal.
yeah, he does at his pre-K graduation and said he wanted a fisherman, no, fisherman, something in
All right, darling, when we get done with this thing, call Jason.
your son.
Yeah, I told you I would. You gotta remind me tomorrow.
And then so now sort of what we think. Yesterday he was asking me the difference between jail and prison. It's like they go.
Oh,
So I was telling my son about type and Kasi and all that. We were just kind of talking in general.
Yeah.
So all these questions are, so he goes to school.
No, we're gonna put her in there since you're right here.
Oh, that's so cool.
I sent that to Kasi a couple of weeks ago. Oh, that's awesome. Like, I'm gonna bring it up.
Is this the same son?
We're not going anywhere.
Why are we in school? Why?
Is this the same son who wants to use the junior FBI?
Yeah, junior FBI. So I'm gonna go over the ATF.
Dude,
Do something.
that sounds awesome.
So that, well, she's going to choose.
This is the latest one. Take this and give me if it's wrong.
And Darlene, once we don't find one, is that easier, or do you like the real copies you have?
Say what?
Do you prefer to have a digital copy, or do you like to just use the hard?
As long as it's agreed to, I'm not gonna need a copy.
Okay.
If, I'm
You'll
fine.
just use, you'll just, oh, you don't need it at all.
Not if it's, unless, I guess, unless there's a change that needs to be made that I need to make it, I don't need it.
That's crazy.
And that's what they take. How many do you drink? You don't drink anything. I drink. How many do you drink? A lot. 7. I drink water all day.
I know you gave me a card. I need your email address. Does it have your email address?
Justin, were you okay with this?
Does it have your email address? Tell me if you read it. Well, no, but I can go get mine. I have these cards. MC@yourname.com. And this one, if you can't find this, just want to do that. Oh, okay. I think I can find that. Okay. I think I can find it. I won't go.
I remember the exact notes, and I tried to give you the exact words.
Oh, yeah, that's,
That's as good as I can do. That's good. And I will email you this tonight.
The court has no right.
I mean, you can. I'll get it. No worries. Okay.
Standard one, standard one.
Sure. You'll have to tell me what it is.
The normal, the court has no right to indicate any matter of opinion as to any matter of facts of that language.
It's in there, right?
No, she does the first sentence, not the second. We're page, on the original, page 9,
I'm not, I hear my original what?
under evidentiary instructions, first paragraph under evidentiary instructions.
And you want the whole thing in there?
Yes.
I'm not familiar with what you're talking about.
It says you are instructed you're not to allow yourself to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court is not intended to, blah, 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 and if the court has, and you must hold on disregard that one.
Right.
Oh, okay.
All right, we can get that to Darlene.
So Darlene, looks like I will be sending it to you to add that. Or if you want to send it to me.
I'll send it to you.
Okay. Darlene, what's wrong with this thing?
Oh, yeah.
Starting.
What is it?
You gotta redo this.
Where's the indictment? I just checked one.
The times about the prosecution called upon question judgment.
So.
No. The court has no right by any word or any action to indicate any matter of opinion.
She did it by Kristopher Love to intentionally shoot her. So, because the murder is the intentional murder. See what I'm saying? So she intentionally.
This is what usually follows in all criminal cases.
Yeah, that's not what she's talking about, though, when that part where it says you cannot, you are not, right there, starting with you are. That, she wants that, he wants that. And you must totally disregard.
But you don't want this part with just that one phrase?
No, see, what she's just got this language. He wants that whole paragraph.
But you said you don't want this part?
Yes, I do.
Okay.
That was Kristopher Love's name on his cell.
She doesn't need
You know where they came. I still haven't got it, darling.
I'm not connected to the internet. I'm going to back it up on a disk and bring it to you.
Oh. If you want to just tell me, I can type it in.
Oh, okay.
You think that would be easier?
Sure. You ready?
Yes.
You are instructed that you are not to allow yourselves to be influenced
I have that first
in
sentence.
any degree whatsoever.
By what you think,
okay,
what you may
okay.
surmise the opinion of the court.
Okay, the next sentence is the court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, comma, nor to indicate any desire respecting its outcome, period.
Respecting its outcome.
Yes. The court has not intended to express any opinion upon any matter of fact in this case, comma, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, comma.
Wait, hold on. If you have observed anything which you have or
may interpret as the court's opinion upon any matter of fact in this case, comma, you must wholly disregard it, period.
okay. So, the court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinions on any matter of fact in this case.
Upon any matter,
Is it opinions or opinion?
singular.
Singular. Opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it.
Correct.
Okay. Okay. New copies coming. George, can I email you and Marlo this final version? That would be great. Or do you want a hard copy now?
No.
Yeah.
Well, whenever,
Okay.
just as long as we get it on the record that we're done.
We need to file stamp it anyway, have a copy.
Okay. George, what's your email?
Gunner at mfplaw.com. Gunner, like Tail Gunner, at mfplaw.com.
Good.
I'll sneak out of the county support.
Owner Finn Price.
Yes.
Are y'all ready to get on the record, George? Are you ready to get on the record?
I am ready to get on the record, Your Honor.
All right. We're on the record outside the presence of the jury. Both sides have had an opportunity to review the charge. Are there any objections or requests for additions from the state?
None from the state, Your Honor.
Any objections or requests for additions from the defense?
From the defense, Your Honor, page 9, the defense requests that the court delete the following language, and on the proposed charge, it will be the third full paragraph of page 9. We ask that the court delete the language which reads as follows, quote, "You are instructed that you may consider all relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the defendant and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense alleged in the indictment. And quote. Specifically, that might be applicable if this was a self-defense scenario or something along those lines. It is inapplicable here, and to put this language in here is to point out and emphasize certain evidence. The statute to which the state will rely goes to admissibility, and if we were in a self-defense scenario, it might very well, and I wouldn't want the instruction. Here, it is just merely pointing out everything that the state wants to point out between the accused and Dr. Hatcher. The court is not permitted under Texas law to emphasize, point out, or do anything which would give more weight to any evidence on any matter of fact, and that is exactly what this instruction does. Given the specific type of murder we're talking about here, it is irrelevant, and it should not, and legally should not be an instruction to the jury. The state is obviously allowed to argue all of this evidence, and for whatever weight the jury wants to give it, but to point it out by the court is to give emphasis to the state's case over the defense case. It simply should not be done. We ask that it be deleted in accordance with her rights, due process, due course of law rights under the Texas Constitution, and her due process rights under the 5th, 6th, 14th Amendments to the United States Constitution. We ask that that be deleted.
Yeah, that language tracks the language contained in Article 38, 36 of the Code of Criminal Procedure.
All right, denied.
We have no other objections or requested instructions.
Thank you. Off the record's closed. We'll see you all in the morning. Oh, wait, you need to be here earlier to get your evidence. Yeah?
I'll be here.
Okay. Well, y'all have all been here early. It doesn't matter what time you get here, but we're going to allow 45 minutes aside.
Is it do you intend to take a break? We're just going to go 45, 45.
We're going to go 45, 45.
Oh.
I mean, they're going to be fresh when they get here with one right into argument, so, yeah.
It is permissible for us to split our
Sure. You'll just need to let me know how much time you each want. Are y'all going to do 15, 15, 15, or have you decided that yet?
They're going to take whatever they want to have. I don't think
Okay.
Judge, Jacqueline, if you want the final version, do you want it now or do you need that ready?
That'll be fine. That ain't right. What you forgot? Whose code is that?
That was one that's not used a lot. See how far on his
Maybe I don't have to look up the law. Maybe I just know it.
Maybe I just know.
Well, if I didn't know it, I'd have to read it a whole lot just like y'all.
My bag is upstairs.
You're just no normal thing. Your badge.
Oh, here it is.
All right, we'll see you on the one.
Is that the big water down there underneath?
I'm gonna put this away away.
Look at this fancy one.
If the defense requested seconds of testimony tonight, do you all want?
Oh, that's me.
Yes, sure.